question?
Any questions from any board members? Do you have any questions for the assessor's office?
Yeah, I'd like to know when we send our letters to the assessor for a refund request, what information do you transfer to the refund committee for it to base its decision on? Because what we're talking about is elected officials and appointed officials who have to make a decision that could impact their political careers. And I'd like to know, what information do you present to them?
Well, they got your entire packet. They got the same thing we got.
Well, at first, we only sent a letter. We cited certain things. We incorrectly cited, not a lawyer, but erroneously, I cited the homestead exemption, and admit to that, but everything contained in the letter referred to the 4% legal resident exemption ratio, along with the letter of the approval. And my question then becomes, if you have an approval and you present them with the approval and you present them with all of the evidence that we supplied to you, there's no question that our domicile, which is the major question in this matter, our domicile was established in July of 2014, living at a KOA campground, awaiting the construction finish of our property. We have lived here since 2014. We filled out an application under penalty of perjury. We certified it. We gave you driver's license, registration, voter ID card. You can't vote in 2 states. Our voter ID cards are dated. They were given to you. In fact, one of the things that this assessor...
Excuse me, sir.
Yeah,
This is just for questions.
Oh,
You're
okay.
going to have 20 minutes
Okay.
to move forward with your argument.
I'm sorry, I thought we
okay?
only had 7 minutes. And
No.
Okay. All right.
You have
So
20
then
minutes.
the overlying question is, what internal information, what file does the assessor give to the refund committee for it to base its decision on? Is it just my letter? Do they present anything else that you have received from us? Does that get given to them?
Oh, absolutely, yes, sir. They had, everything you have submitted, the tax refund committee has had the opportunity to see.
Okay.
They have seen it.
Then the next question I have, in one of your slides, and you eloquently described it, is a income tax statute. The limitations on time is an income statute, a personal income statute, where you have to file income tax returns, you have to, corporate, you have to file, quarterly estimated taxes and things like that. So why would the assessor's office, who has the responsibility of making sure they comply within the statute for real property tax, not income tax, real property tax,
That statute.
why can't we reference that refund statute that is in the real property, 1755, 1260, 1755. It's on the front page of the treasurer's website, that it says any tax years that proof is provided, period. It's unambiguous. 1260, 1755
Okay,
is the statute that applies to real property.
That statute that you're referring to may apply if there is an error on the part of the county. The county has committed no errors in this situation.
I love it. Thank you. That's all I have.
Okay. It's Mr. DeNapoli. I want
Yes.
to pronounce it correct. So
Yes.
you have 20 minutes to proceed with what you would like the board to hear.
Okay. First of all, I'd like to thank all of you guys. I start off by explaining that I'm a little bit passionate about this. This has a real impact on my family, our situation. I have a son going off to college. I was responsible for the airspace in Afghanistan during the withdrawal. When the Biden administration decided to cancel the NATO contractors, our company was essentially ignored. We told them you're in a landlocked country. We told them we are the air traffic controllers. They rejected it, they denied it, they didn't hear it. And for however many years now, they've denied $6 million that they have owed me for the damage they caused to my business. So I've seen corruption at the highest level, and I'm starting to reveal it down here at this local level. And it's time for accountability. That's the bottom line. This entire presentation you have is conjecture. It's not law. In fact, this assessor I gave you guys in my response to their evidence has not even provided a scintilla of evidence to support anything he just said. They've literally produced one document that they themselves inserted a word provisional, which is not contained in law. It's unlawful. It's erroneous. It may be a department policy, but you're going to love it, and I'm going to explain to you that we're going to fix this with 3 simple documents. Everything you need to guide yourself and your decision on the law, what the law is in what I labeled MLD, R2, R3, and R4. This is what they're taught annually. The assessor goes through a reassessment or goes through an education program where they're taught what is, by the South Carolina Department of Revenue, they're taught what is the authority, the law that guides this statute. So you have 3 very distinct cases that guide legal residence, because originally legal residence didn't have a specific definition. Then there was a case in 1940 that went ahead and defined legal residence to mean essentially the same as domicile. Then you had further cases, and it's all in here, so I don't want to waste my time going through that. It's all in here, everything that they are trained on, their guiding principles by the South Carolina Department of Revenue. In fact, specifically, MLD R3 is a revenue ruling, number 97.4. This is direction they are given to keep them up to date on the law, the general principles. Legal residence definition, a property in a person's legal residence if the property is owned and occupied by that individual as the individual's domicile. Domicile has its usual meaning and is considered to be that residence where a person has a true, fixed, and permanent home and a principal establishment, and to which, whenever a person is absent, has the intention of returning. That's cited from Phillips versus South Carolina. A property does not qualify for legal residence unless the owner-occupant applies for the county, as he correctly said, applies for that special assessment. So, again, I don't want to take much time here, but there's one thing that I do want to respond to that was later in their presentation. They say we were enrolled in this, this is one of the smaller matters, but it's important to get it on the record. They say that we were enrolled in this, 2022, we were enrolled in this tax payment plan or something to that effect.
Installment.
Mhm. If they actually read the complaint that we sent, the protest that we sent, it is actually, there is a claim, there is a issue number 2 in the second filing that says we're invoking the set-off doctrine, basically for our 2024 taxes. That was on January 3rd. On January 30th, they're alleging we failed to make a payment, so we got kicked out of the system. This is not new. This is a common theme. They make up their own law, they follow their own rules, and they don't provide a scintilla of evidence. So what I'd like to do is remind you, their issue of us being kicked out of a payment plan program is because they failed to read and examine our actual protest. It's issue number 2 that is before you guys, and it specifically invokes the statute that says, it basically says, you can pause on your property taxes while this matter is going on, and you wait till the end, till there is a final decision, And that will determine if there is a set-off, if there's a credit, if there's an amount due, whatever it is. It's a statute, it's a law. So we invoked that, made them aware of that, they disregarded it, and now they come before you alleging that we were kicked out of a program, we failed to do something we were obligated to do. Let's take it a step further. 3 documents are going to give you everything you need to know about this case. First of all, this is their packet. I don't know how many pages it is, 20 pages, is all they've presented, and not 1 ounce of documentation they have in their possession. This is a FOIA request that will show you they have been intentionally concealing exculpatory, material, and impeachment evidence, and their case is done. It's dead with that alone. That's prejudicial, because what they're coming before you and telling you is a flat-out lie, and they know it, because these are their records. This is what they have in their control. This is what they decided not to bring to court today. They come to you with their hands unclean. The doctrine of unclean hands. You can't say I didn't do something when you yourself are concealing the fact that I did do it. Sorry, I apologize. MLD 273 from my evidence packet. Just so you know what you're looking at when you look at it. This is a 4% application that we filled out in 2015. Everything that is required under the statute is here. Don't take my word for it. Look at their internal checklist that shows we produced all the documents required to receive the 4% assessment ratio. We sent our application in. They went through their checklist first. Then each of these sections has a different person signing off on it. It's red because I'm highlighting for you. But everything that the law requires is right here. And at the very bottom here, for office use only, approved or no. Those are only 2 options. There's no provisional approval. This is smoke and mirrors. This is to cover up their error and try to shift that burden to me. It doesn't work. In 2015, you approved our application. Your internal documents show we completed our checklist. We presented our taxes. And in this FOIA request, there's no tax returns that we submitted in their record. So the question is, where are they? We submitted them. You acknowledge that we submitted them. You approve the fact that we submitted everything required. And at that point, what the law says is when the taxpayer has met their burden and obtained the 4% assessment ratio, or it's so confusing whether you call it an exemption or whatever. I get so confused. You do too? So once you do that, those are the steps you have to go, which is you have to file the application. The Constitution and the law says a legal resident is entitled to 4%. It doesn't say anything about there's a default 6% ratio. I understand that that's the position they take, but the only thing in the Constitution that describes a 6% is agriculture use, not domicile. So over time, I don't know where over time, it's evolved, and somehow it's become a quote-unquote default as used by